Good evening, this is Rahul Reddy. We're live here from Houston, Texas. Reddy Neumann PC brings in immigration updates every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, there's a lot of rumors going on these executive orders. A lot of questions are coming up. I want to ask you some of the things after the executive order. Can we file a H-1B in the lottery system right now?
Yes, we absolutely can.
Can any non-immigrant visa person who is outside the person right now, like O, P, Q, L, N, all those visa people, H1s, L1s, L2s, can they all come into the United States if they have a passport visa stamping?
Yes, absolutely.
And can you file an adjustment of status if the priority date is current for the employment-based immigration people?
Yes.
Can you file an I-140 after this executive order? Can you file an I-140 right now if you're eligible for it?
Yes.
Can you file a PERM application right now?
Yes.
Can you file a H1, L1, O1, P1, Q1, TN? Can we file an extension of status? Can you file the and can you file a transfer of these applications if they're eligible for it?
Yes, absolutely.
Can a student visa person who's outside the country right now, can he enter into United States right now, even after the executive order?
Yes.
So what changed in the executive order? Why is all this trouble? I mean, everything what we know about has been as it is. Nothing has changed. Why is all the trouble about? What is this executive order?
Yeah, so the executive order is quite narrow. It is only for those that are applying for an immigrant visa. So you have to make sure you understand that when they use certain words in these orders, they have a set meaning. They don't, when we talk about immigrants, the common sense meaning of immigrant is anybody who's from another country.
Like L visa, O visa,
Exactly.
P visas too. Yeah.
But here, when we talk about immigrants and immigrant visas, we're only talking about those seeking a green card who are outside the United States. So that is the only people we're talking about. And even within that, it is, there are all kinds of different exemptions for it. So really what we're talking about is in the employment-based area, the few people who consular process their green card after they get the I-140 approval, whose priority date might be current right now, cannot finish the process at the consulate. That's such a small percentage of all of the
Is that for the whole lifetime or is it only temporary?
It's temporary. That's another good point. We're only talking about 60 days. Is there an option it could be extended? Yes, but it can't be extended indefinitely. And I think that the overall impact of the order on employment-based immigration is quite low.
Emily, let's go back to last week when we did not have the executive order. We just had the tweet, and we predicted at that point of time certain things. Especially we said we are expecting that the people who are non-immigrant visa people, like H1s, O1, P1s, F1 visas cannot enter into the United States. That's what we predicted it would happen. Is that correct, or can they enter into the United States?
No, we were thankfully wrong on that. So when he tweeted, he made it sound like all immigration was being blocked from coming into the U.S., but non-immigrant visa holders, those that are on temporary work visas, student visas, can still enter even after this executive order.
So compared to the last week, restrictions where we said it's most probably will not be applicable, this executive order is more restrictive, only for the people who are coming on a green card visa application directly from outside the country into this country. And that too only temporary, that is up to a period of 60 days. So most of the audiences that will listen to this, most of them will not be affected because most of our audiences are employment-based immigration who normally adjust the status in the United States, who are the people who are going to file the H-1B extensions, O1, P1, L1 extensions. They will not be affected. And those non-immigrant visa people who want to come into the United States are also not affected. Can people at this point of time, if the consulates are open, apply for the non-immigrant visa, non-immigrant, like O1, P1, L1, O1, H1, F1, can they still apply and come into the United States?
Yes, so the executive order does not block any non-immigrant visa applications. So the only thing stopping people from getting the visa right now is that the consulates are closed and not accepting interview appointments due to the potential issue with, the virus spreading. So that was already there. So for non-immigrants, really nothing has changed. We just have to wait for the consulates to reopen.
Emily, in the executive order, I read something and the people are very scared about, and that 30-day thing to put additional restrictions on the non-immigrants, though. Does it mean that they are going to put it? What exactly in the executive order mean? And what do you anticipate? Remember, last week you anticipated that the non-immigrant visa people will have restriction traveling into the United States, but that did not happen at all. I mean, now, what do you anticipate in this additional restrictions on the non-immigrant visas? Of course, this is just an estimate, what we're telling right now. Please keep tuned to Facebook and YouTube. If you're a business non-immigrant visa people in the United States, this is the best channel for you to log in to get the updated information. We give you the information what you need, what we understand you much better, because we deal with your kind of cases day in and day out. So Emily, can you tell that what is this 30-day rule? Does it mean the whole sky is going to fall down on the non-immigrant visas? And what could the executive order be possible be?
Right. So over the next 30 days, we may see some additional measures that could impact non-immigrant visa holders. Now, what power does the president actually have? What are we anticipating? So he said he's directing the Department of Labor, who is in charge of PERMs and LCAs, the Secretary of State, who is in charge of visa issuance at the consulate, and Department of Homeland Security, who's in charge of CBP at the border. He's directing those three agencies to review non-immigrant programs and make recommendations based on what's happening in the economy at that time. So at this point, there isn't even a guarantee that we'll have another executive order in 30 days. We're just doing a review. Now, even if they do this review and they decide to issue another executive order, let's look at the current executive order and what powers the president has. So in the current order, what is notable is that people who already had received their immigrant visas but had not yet traveled into the U.S. were not blocked by this executive order. That suggests to me that if we also get an executive order that blocks non-immigrant visas, thinking the same way, those who've already been issued a non-immigrant visa should still be eligible to enter. Now again, this is our guess, but that's kind of basing it on what the current order is. We might expect to see the same for this order, that those that have already received their visas should still be able to travel. What I think our biggest potential impact is people who have not yet applied for the visa. So if you were planning on traveling over summer break and need to get a new H-1B visa stamp or an H-4 visa stamp in your passport, or L or O or whatever the case may be, you may not be able to get that visa to be able to come back. So if you're inside the US right now, my recommendation would be try to avoid travel while we have so much uncertainty, because there's no guarantee that you'll be able to get a visa stamp if you need one. But if you're outside the US, watch those visa appointments, schedule the appointment as soon as they become available so you can get your visa issued before any second executive order comes into play. I don't think he has the power to block filings with USCIS. I don't think he has the power to block filings with the Department of Labor. When he's telling the Labor Secretary and the Secretary of State to review their programs, my take is maybe he's going to direct them to modify the forms so that we might have a new question on the LCA where the employer has to certify that they've not displaced a U.S. worker. That's kind of what was in the original draft that was leaked to the press of the first executive order, is there might be some sort of certification. So maybe the I-129 form will be modified to add an additional question about not displacing U.S. workers, or maybe the LCA will be modified. But I don't think he has the power to block filings with USCIS or Department of Labor. We have to think about this, across the country, across all industries. There are some industries that still might have a shortage of U.S. workers, and there are other industries that don't. That if you're waiting tables, or if you're in the hotel industry, yeah, you might have difficulty finding a job right now. But if you're in other industries, there may not be enough workers. So I don't think there could be a block across, we can't treat everybody the same. That's my take on it.
One thing I may differ with you completely, Emily, is that he doesn't have the power. You said all those things. One thing I can tell is that he has the power to tweet. There's nothing you can do about it. He has the power to tweet and has been tweeting. Doesn't mean that it will become a law. A tweet of a president does not become a law. There are procedures, rules, regulations that everybody has to follow. This is a land of law. So everybody has to go through. Tweet does not become law. So when he tweets, don't get panicked, like the way what happened on April 28th, people started calling right in the middle of the night. My phone goes bang, bang, bang. What's going on? Well, the tweet came in. Well, tweet doesn't become a law. So please be watchful. We have noticed that it is really throwing people out. The immigrants are already, just like all the entire world is stressed out. We understand you are not living in your home country, you are living in a foreign country, and you are subject to an additional regulations, rules that a US citizen or a US person don't have to follow. You have to follow extra rules. We understand that. But we tell you that please calm down. If you get a tweet in the middle of a night, if you get something, please don't panic. Please come back to our Tuesday Facebook and YouTube Live. We will update you. Don't get panicked. Emily, you said that a lot of these things, the restrictions might not come, but we have also noticed that the application support center where people take the biometrics, and also the field offices where the adjustment of status interviews go on, and also the consulates are closed right now. Do you have an estimate how that's being done and when they are going to be open?
Yeah, so USCIS did come out with an alert late last week, if I recall correctly, for the application support centers and field offices will remain closed most likely till June 4th is what they're anticipating at this point. So that is very problematic for people who are applying for their H4 extension, L2 extension, TD, everything that's filed on an I-539 requires biometrics now. And it becomes even more problematic for those that have an EAD going along with it. The H4 EAD and the L2 EAD are going to be held up because the biometrics can't be done, and it's looking like that might last until June 4th.
Emily, let's difficult of the main topic. One of the things that is concerning to the people is that there are people who are on B2 visa here. They entered United States and they wanted to exit in February, March because of the COVID. They think that things will get better, but doesn't look like things are getting better. Now they are stuck, their I-94 is expiring. Now also there are some people, Emily, that have filed for the H-1B extension. Their extension got denied and their I-94 expired. Their change of employer from company A to company B got denied, and normally we used to tell these people, please leave the country. Now we can tell leave the country. What can they possibly do? They can't swim from New York to Bombay. What is the solution for those kind of people where their I-94 expiring? What is the best solution for them?
Right. There's no special provision that's due to COVID-19, but USCIS already has a regulation in place that allows for late filings to be forgiven if you can show that the late filing is due to extraordinary circumstances beyond your control. So they re-announced that rule. Again, it's a rule that's already in place. We call it a Nunc-Pro Tunc request. That means please forgive my delay in filing and put me back in the status as if I never fell out of status. So if you're in that situation where your I-94 has already expired and you ended up with an unexpected denial, we're generally recommending that you file a late change of status to B2 to request a 6-month stay. That's the maximum amount of time that you can request, and then make your travel arrangements whenever you can within the next 6 months. That would be same thing if for some reason, we have a lot of cases where we're filing change of status to H4 where people are losing their job for H1 or they're being furloughed or benched and they have the H4 as an option. You can file a change of status to H4 as well, and if for some reason it gets filed late because of everything that's going on, even in our firm, we've got most of our staff working from home and people are just coming in one day here and there in order to file things. So things do get delayed. So if a delay happens that is out of your control, that's caused by the stay-at-home, work-from-home orders and the COVID-19, you can make those arguments in the filing and file late, and USCIS should excuse those.
Can we go to the question and answer something? Dal Geeta has this question. She's a registered nurse. She's working with a COVID patient. My salute to you, Ms. Geeta. It's very nice that you're doing it. Proud of you. Thank you for doing it. She's on H4 status right now. She received the work authorization based on the 485, but her I-140 got denied right now. Oh, thank God. What kind of persons will get I-140 denied? Poor. Could it be some not nurse, somebody else? God bless her. But anyway, coming to the point, since she's asking the question, does she need to leave the country immediately? She's on H4 status. Her H4 status is valid, but she did work on EAD though. Once you work on the EAD though, you are considered to have moved to the 485 application. I would recommend you drop an email to me, Dal. I will call you back tomorrow. You don't need to pay any consultation. I will call you back tomorrow. Make sure you include your phone number in your email. I will discuss with you the options that you have.
One of the questions that's come up multiple times is when will premium processing be available? So we originally had the suspension of premium processing only for the H-1B cap cases, and then later that was extended to every kind of case, so nothing can be premium processed right now. When will it be back? Unfortunately, when USCIS made that announcement, they did not give any indication of how long the suspension was going to last. I think it's 100% dependent on how things go with this virus. Their staff may not be able to come into the office. They may be under work-at-home orders just like we are, so things certainly take longer, and they're not able to comply with that 15-day processing time. Will it be back in the summer? We don't know. Could it be back in the fall? Possibly, hopefully. I think it really depends on how quickly we get this virus under control.
Question from Riaz is the perm processing going on? Yes, it's going on. We are still receiving approvals every day. We haven't seen much interruptions on the perm processing at this point of time. Question from Vrinda Kulkarni from YouTube has this question that if one of the spouse is having an ITIN, this is the IRS that gives a substitute to the Social Security number to file the income tax returns. If they filed the joint income tax returns, can they get the stimulus check? The answer to the question, what I checked with the CPA, you're not supposed to receive the stimulus check because you filed as a non-resident. That's how they have been told. Normally, ITIN people file it as a non-resident and they are not eligible to get the stimulus check. Even if one spouse is an H-1B who is actually files normally as a resident, if another spouse is an ITN, they will not get the stimulus checks. That's what the CPA answered to me.
Pavan from YouTube has a common situation that's coming up right now because we don't have premium processing for the I-140. So H-1B max out date is coming up in July, and the perm wasn't filed before the 6th year began. So he wants to know if he can get the perm approved by then, is he eligible for a 1-year extension without having the I-140 approved? And the answer is unfortunately no. You are only eligible for a 1-year extension if your perm has been pending for at least 365 days. Since we know your perm was filed after you entered your 6th year, it won't be pending for 365 days by the time you reach your 6-year limit. You are going to need that I-140 approval in order to extend the H-1B beyond July. Or once you do hit the 365-day mark, then you'll be eligible for a 1-year extension. All that depends on when your perm was filed exactly.
Emily, I want to ask you some FAQs with regards to the COVID situation where the rumors are. Can an employee be furloughed because of the COVID situation right now on the H-1B visa?
No, that would be a violation of the LCA regulations. You cannot bench without pay. So that would basically be putting the person out of status.
Everybody knows the 60-day extension if the I-94 is valid. If they get laid off, they have 60 days for them to move to a different company or move out of the country or move to H4 visa if they're eligible to. Is that extended for 240 days or 180 days?
No, there's been no grace period extension, no extension of stay automatic. Many other countries have done that for their non-immigrants that are in the country, but the U.S. has not. So you're limited to the 60-day grace period.
Because of the COVID situation, if the employer cuts the salary by a certain percentage lower than the LCA, is it allowed under the current circumstances right now?
Just because we have a pandemic going on, it does not give the employer the capability of reducing below the prevailing wage. All regulations regarding pay and working hours, terms and conditions of employment for H-1Bs have to still be complied with even during a pandemic.
What are the restrictions, what was the relaxations that the US government has given it in the past 3 months because of the COVID restrictions that were not existing before?
The only helpful ones are RFE response time. You get an extra 60 days if it was issued between, I think, March 1st and May 1st. So you have more time to respond to the RFE, and for forms, they will accept a photocopy of the original signature. So you can send in your forms with a photocopy instead of sending in originals. That's it. No other, everything else has been not helpful. Lack of premium processing, lack of biometrics appointment, no green card interviews, no consular interviews, no other things have been announced to actually make things easier for non-immigrants.
I'm going to go to the questions quickly. What's available on the, what people are facing. Can the parents on B1, B2 travel into United States? Is there any new rule that will impact? None, AK, this is from AK from YouTube, none at all, because the only restriction right now is airlines are not flying in. Other than that, if the airlines are flying in, then you don't have a problem. You can come in a B2, B1, B2, absolutely not a problem. Suvesh from YouTube has this question. Cap gap, it's a good question he asked, is it only applicable if he is working for the same employer for which the H1 is selected? So let's say he got his H1B selected for company A. Can he work on a cap gap with company B? Absolutely you can. Cap gap is given to you, Suvesh, not to your employer. You can continue working on a cap gap, assuming the OPT and STEM extension, you have a validity to work for that employer. You don't have to work for the same employer for which you got the H1B selected. You can work for any other employer.
Vipul from Facebook says his change of status from L1 to H1 has been approved, and he has an I-140 that's approved, so he applied for his wife's H4 and EAD. But because there's no biometrics, the application is stuck. What options does he have now? So because you filed the change of status to H4, even though you're no longer in L1 status, your wife does continue to be in a period of authorized stay based on her pending change of status to H4. So she is legally allowed to remain in the U.S., but she can't work until she gets that EAD, and she won't be able to get the EAD until they reopen these biometrics. Unfortunately, there's not an option. There's no other option right now. I do have a draft letter that you can send to your senator, your congressman, to the USCIS Ombudsman Office, asking them to waive the biometric requirement for I-539s since the application support centers are closed, and it's causing people to not be able to get the EAD approved. So you can go to immigrationgirl.com to find that template and instructions on where to send it. Maybe we can try to get some changes on that, but there's really no options, unfortunately.
If a person applies for a change of status to B1 or B2 from H1B, can he still look for another employment? Yes, you can look for another employment for a H1B, but be practical. You cannot practically change from B1 to H1B. So if you're an H1B, you applied because you lost a job, you applied to the B1, B2, and then now you want to change back to the H1. It's practically not possible because the timeline for which the B2 is taking is very, lengthy, so it's not practical.
Ultimesh from Facebook wants to know if Company B can file an H-1B transfer while an amendment is pending with Company A. Assuming that your I-94 has not expired, yes, there's no issue with that at all. Company A does not need to withdraw their pending amendment. You're filing a transfer based on the underlying approval that remains valid.
Emily, this is one of the things that we discussed, and you made a very valid point to have all of us think twice. And this executive order, in a way, is beneficial for the employment-based immigration. You explained that if the family immigration is cut off, those extra number of the green card should fall into the employment-based. Can you explain how this executive order is actually better for most of our audiences?
Right. So looking at the number of family-based green cards that are issued each month that will be blocked for the next 60 days, that comes out to a total of about 52,000 green cards. So over the next 60 days, about 52,000 people will not be able to get their green card under the family-based category where they normally would, based on the numbers of prior years. The law requires that family-based green cards, when they go unused, they trickle or spill over to the employment-based categories. So beginning in October, the next fiscal year, we're supposed to see all those unused green cards being added to the employment-based categories.
So practically, if this executive order, if he extends it more, most of the audiences that we have will get a lot of benefits because most of them waiting for the green card.
Exactly.
So this executive order at this point of time, not that we advocate this one is a good one, but is actually ends up to be beneficial to the audiences because the unused family green cards will fall into the employment-based green card, thus by expediting some of the priority dates of the. Realistically speaking about are we expecting a significant amount of movement? No, we are not expecting a significant amount of movement. If the things fall, they can still cover, even though if they are off by 2 months, the immigration and the State Department might cover and finish the entire family-based green cards. Maybe they may not be spillover, but there is a chance it may be spillover. There is a chance. Trump administration has always been prolonging these executive orders. If they keep prolonging the executive orders, it may be very good beneficial for you guys and who have been waiting for the green card. Jiten, I was answering your question with regards to the EB2, EB3 priority date movements. There is a chance for you to get lucky in this one, but you'll have to keep waiting how the things will turn around. So keep watching our YouTube. We'll update you more on as the things develop.
Anand Kumar from YouTube wants to know if an H-1B worker can work remotely or accept a remote job. Yes, there's no issues with working remotely while you are in H-1B status, as long as your LCA and your I-129 petition have the correct work location. That is acceptable. Now, there is a higher level of scrutiny that you'll see. We get more requests for evidence asking for proof that the employer-employee relationship will continue to be maintained because you're not working on site. But assuming that you can document that there will be a valid employer-employee relationship, you should be able to get that approved.
The question that came is that I'm on H4 EAD. I got selected in the H1B lottery. Can I change the company? Yes, you can change the company. However, you cannot move the selection of the lottery from your current company to another company. In other words, if you are working with Company A got the H-1B selected in the lottery. If you move to Company B, can Company B file the H-1B? The answer is no. They cannot file the H-1B. Only Company A can file the H-1B which got selected in the lottery. You can move to Company B. Company A can file the H-1B, but I doubt if they would since you left the company. So you may want to be careful before you move to Company B.
Neeraj from YouTube says a friend of his who's in H-1B status has been asked by his employer to go on an unpaid leave of absence. That is not acceptable. The employer cannot request you to go on an unpaid leave of absence. The employer is required to continue to pay whatever salary they listed on the H-1B petition.
YouTube has this question, Akshid Daka. EB2 485 got rejected due to check rejection. Refile, is there any chance to use the biometric getting reused? Biometrics do not get reused. You have to keep on getting it down. So if you have filed one more 485 application, you have to do the biometrics again. The same thing is true with the H4 extensions. If you keep filing H4 extensions every 3 months, unfortunately, at this point of time, you have to get the biometrics done unless the court gives a judgment against, or probably things work out, the administration changes its mind on it.
Amol from YouTube wants to know if a new LCA is required if the employer is cutting a salary by 30%. So number one, it's important to understand that the employer cannot reduce the salary below the prevailing wage. So if that pay cut would go below the prevailing wage, it's not allowed at all. Assuming the employer was paying much higher than the required prevailing wage and is now cutting the salary down but still meets the prevailing wage, not only do they need a new LCA, but they also have to file an amended petition with USCIS before that change is implemented. Pratyusha wants to know if there's any update on the H4 EAD regulation that was supposed to come out this spring. Great question. So yeah, we've been talking about this H4 EAD regulation for what, 2-3 years now, and we still do not have a proposed regulation. It's still waiting with the OMB. They were going to do their review, wanted some updates on it. There's a lot of back and forth on that, and nothing has happened. Still nothing proposed on the H4 EAD regulation.
Self-made from YouTube has this question, how long it's taking for H1 to H4 plus EAD? It's taking anywhere between 7 months to 12 months right now to get the H4 plus EAD. That is the current condition right now. It may change as things go on because of the COVID situation. Dharmendra Gohul has this question, is it good idea to apply for the EAD just to get the Social Security number? Yeah, if the person is eligible for the EAD, I would apply for the EAD for a lot of different purposes. Just apply, get it done. You never know what you may use it for. So I would recommend that you get the EAD and then apply for a Social Security number.
Neeraj from YouTube wants to know if the I-129 modification that I talked about earlier would be applicable to new H-1Bs or transfers or renewals. So first I want to mention that was a guess. That's one thing that I think that President Trump could implement is a change to the I-129 form where they might ask an additional question about whether U.S. workers were displaced or laid off before filing this petition. So typically that would be done through a change to the form. So anytime the form gets changed, it first has to go through a process of approval with the OMB, and then the new form is published, and from whatever date they say going forward, you have to start using the new form. So it would apply to every I-129 that's being filed after the new form takes effect. We see the new form happens all the time. It just happened recently when the public charge rule came out. The I-129 form got changed to add more questions about public benefits. The I-539 form got changed. So having the forms changed is nothing new or out of the ordinary. They happen all the time. So whenever they change it, you have to start using the new form for every type of case that's being filed on that form going forward.
Questions, is the LCA getting delayed from the Labor Department? We haven't noticed any LCAs getting delayed at this point of time, even though because of the COVID situation. We haven't noticed much at all. Can I file a H-1B when H-4 and EAD is still pending? Yes, you can. If you got selected in the H-1B and your right now extension EAD is pending, you can file a H-1B. Absolutely no problem. This question is from Nagarajan from Facebook.
Amanpreet from Facebook is getting close to the 240-day rule and just received a request for evidence and wants to know what happens next. So the 240-day rule, this is on extensions with the same employer. Once the extension is filed, if your I-94 expires while it's pending, you're eligible to keep working for up to 240 more days after your I-94 expired based on the pending petition. So if it's still pending beyond 240 days, you do have to stop working until you get the extension approved after that RFE.
Is it good time to apply for the EAD because of the COVID situation? If you're eligible, yeah, you can apply. I mean, right now, things are functional. May not be 100% functional, but things are functional. This is not a complete lockdown situation like where we see in countries like India, but here we do see USCIS and all those people still working. And most of the USCIS officers are actually working from home even before this pandemic. And now previously the USCIS officers, they used to go to ball game, they used to go to clubs, they used to go to bars, restaurants, movie theaters. Now they can't go anywhere, they have to work more. I mean, what can they do? Sit at home and work. So yeah, it's not at all, it's not as bad as what people think it is. Most of the government officers that deal with the business immigration are already working from home, so it's good for them to work harder because they don't have anything else to do. So do file the EAD, nothing wrong with it.
Madhavi from Facebook had an H-1B approved back on April 6th, but still hasn't received it yet and wants to know if there's any way to get that approval notice. So typically with USCIS, they require you to wait for at least 30 days from the date an approval was issued before you can determine that it's been lost in the mail. Once you cross 30 days, only the employer or their attorney can contact USCIS about the non-delivery of that notice. They can do that through an e-request online or by calling customer service. But you personally, as the employee, cannot contact USCIS about it.
Sanjay from YouTube has this question: how long the perm process is taking? When can we expect the premium processing for the I-140 to be reopened? Sanjay, we're noticing the cases that we filed in November and early part of December are getting adjudicated right now, which is in April 28th, somewhere in April 25th to 28th. Now, with regards to the premium processing of the I-140 though, that is very hard to predict because we don't know how long it may take for the whole COVID situation to cool down. Though the Trump administration wants to restart the things, go to the normal things, it may be a long time. However, Sanjay, though, what we noticed is that things of I-140, even if you file in a regular processing, they're getting adjudicated faster. The main reason, as I pointed out, the officers that are working from home have nothing else to do. They can't get out. So they're working more harder. That's what we noticed in some of the cases, not all the cases. So you may be lucky in that, that if you file normal processing, things get approved.
Venkatesh from YouTube wants to know if the executive order impacts any of the I-140 applications that would be filed in the next couple of months. Our expectation is no, it does not impact the I-140. You can still file the I-140 with USCIS. If you are consular processing your green card after the approval of that I-140 and we still have this executive order in place, that is what would be blocked. But most employment-based immigrants don't consular process after the I-140. They stay here and file the adjustment of status, and that is not impacted at all.
Emily, I want your attention on one of the things what Tanmay has presented here is the day one CPT. Why do you consider day one CPTs as scams? You've been advising, scams. Of course, we saw after you advised so many times, we saw University of Farmington busted up and another university busted up recently. Why do you consider the day one CPT universities a scam?
Well, it's not so much my opinion. This is the opinion of USCIS that we get in requests for evidence and denials. We see all the time that people that are in these programs and file a change of status to H-1B get a nasty request for evidence asking about how they qualified for this day one CPT and whether they met the requirements for it. And time and time again, regardless of how many documents we submit, people were getting the change of status denied. USCIS specifically said that this CPT was not properly authorized, therefore you violated your F1 status and need to leave the country. So it's not just us proclaiming that it's not a good idea. This is coming from decisions we've received by USCIS telling us that these were not properly authorized. On top of that, we see the transcripts from visa interview appointments, from CBP when people are entering the United States. And these officers, consular officers, CBP officers, refer to these specific schools as pay-to-play schools or fraud schools. I mean, if the immigration officers refer to them as that, you can only imagine that maybe they're not good schools to attend. Maybe it's because those programs are being offered as a way for people to keep working. That is not the purpose of the student visa. The student visa is for you to study. And what we've seen is people study for maybe 3 classes total in one whole semester, and the rest of the time they spend working 40 hours per week. In my mind, that is not studying.
And then, Tanmay, another thing is that out of the 8,900 institutions that are issuing, that are eligible to issue the CPTs, the Day 1 CPTs, only a select few, less than 10 universities are actually issuing the Day 1 CPTs. And you asked another question, are there any genuine universities that can issue the Day 1 CPT? There are exceptions, there's no doubt. In some of these medical universities, particularly if some person is doing doing a nursing or some doing an advanced research though, if their research or if they're touching the patients, treating the patients within their university facility, under limited circumstances, on the day 1 you join, especially in the medical field where the nurse or the doctors or the dentist have to touch the patient, deal with the patient, it may be allowed for them. I have also noticed that some of these doctorate students that have to mix the chemicals, they have to sleep in the university if they have to and mix the chemicals. Every 2 hours they put alarm and they mix the chemicals to do whatever they are doing, what they feel is good. In the university premises, yes, they may be allowed, but there are very specific situations we would want you to check with a lawyer. One thing, these universities are conducting classes at least 3 to 4 days a week, live classes. And the Day 1 CPT work is actually occurring on the university premises. You are actually subject to live nearby the university, not if the university is in California, you're going to live in Rhode Island. I don't know how that works out. So these are the situations. You have to live near the university is reputable. You know what reputable university are. I don't have to explain. And the work is getting done on the facility of the university.
Renbala from YouTube wants to know if it's better to file an H-1B extension now before the anticipated executive order on non-immigrants comes into play. Well, I would say in general, it's always better to file the extension earlier rather than later, because we've seen so many times we get questions, oh, my 240-day limit is coming up, what do I do? Well, that's why you file early, so that you never get into that situation where you're 240 days after your I-94 has expired and you still don't have your approval. So yes, file early regardless of the executive order. That being said, even if we do see another executive order on non-immigrants, as I mentioned earlier, I think that it would be limited to individuals outside the U.S. who do not currently have a valid visa. I don't think the president has the power to stop people from filing petitions with USCIS.
Hemant has this question, what's going on with the asylum filings? Hemant, we have to say that our office does not keep up very much on the asylums. I have to admit that we are not good at it. Amit has this question from YouTube that after I-140 has been approved, how many employers one can change? One condition, Amit, after the I-140 has been approved and it's been more than 180 days, the I-140 has been approved and it's not been withdrawn before January 17th of 2017. that belongs to you, Amit. Practically, how many employers after that you can change? Oh, I would give a number. If you cross, you check with me after that. 100 is what you can change. If you cross that, you check with us for the next time if you intend to cross more than 100.
Nilesh from YouTube wants to know which is a better way to extend an L1 visa, filing with USCIS or through the consulate. So I'm assuming this is dealing with a company that has a blanket L approval. So when we have the option of going to the consulate is generally a faster option and I don't want to say less scrutiny, but it's generally easier to get an L1 extension approved under a blanket approval by going through the consular processing route than filing with USCIS. USCIS has a ton of requests for evidence on L1 extensions, lots more documentation required, processing time is much longer, and we do not have premium processing right now.
Suhas has this question. It looks to be very odd that he got an L2 RFE because of the mother's birth name. Really? Well, Suhas, welcome. This is the way it is. I can address this much better because one thing is my name got messed up in the immigration. You think my name is Rahul? No, that's my family name. My name got messed up. How do we resolve it? Suhas, I would say that one thing, try to get as much documentation as possible why there is a little bit difference in the name of the mother. One thing I want to get at, Suhas, is that whenever there is an issue of the parent and child relationship, when there is an RFE on that though, I want to take it a little bit more seriously and shoot the things down once and for all. Get the DNA certificate and resolve the whole issue. I mean, everybody believes DNA right now. Get the DNAs done. That will resolve the issue. I have done it time and time again. I had one time at my I-130 485 case got denied. I was so petrified of it. I refiled the application with the DNA and got that approved. Then afterwards, whenever I get any RFE on the birth names of the mother, father, I just get the DNAs done and resolve that issue. It's going to be easier. It's going to be less expensive to resolve those issues. Ram Prasad has this question from Facebook. Can H4 EAD do a business? He's particularly referring the consulting company business. There is nothing wrong, Ram Prasad, for the H4 EAD to do any legal business. However, we want you to have a contingent plan just in case when the EAD extension when it gets delayed, what you're going to do. All those things you need to be very contingent, especially when you're entering into the consulting business or you're signing any of the immigration documents. If you're signing any of the immigration documents, you can, but I just want you to check to make sure that you're complying with every rule and regulations that possibly exist so that you don't get into trouble. But technically speaking about, yes, H4 EADs can own consulting companies.
Satyam from YouTube wants to know, how does a pending H4 and EAD application get impacted if an H1B is applied for that person? So there are two separate applications. So the H1B would only be dependent on the outcome of the H4 application if the current H4 status is expiring before October 1st. I'm assuming that the H1B is a cap case. But if your H1B is ultimately approved and you are in H1B status and no longer need the H4 and the EAD, definitely you would want to withdraw the H4 and EAD application so you don't end up in H4 status after you already got your H1B approved.
Emily, can you explain about this working from the home location? There are two situations. One situation is that if the end client or the employer location where on the LCA location is in the same location as that of the home, and if the person is working from the home, same job, nothing has changed, do they need to file an LCA amendment?
No. So the LCA is valid not just for the specific address listed on it, but generally the whole county or the reasonable commuting distance from that location. So for example, our office is here in Houston, Texas. I live in a suburb of Houston. I'm working from home right now. If I were an H-1B worker, I would not need to file an LCA or an amendment because my current LCA covers the whole location.
Please note that when she's saying about, Texas is a huge state. To cross the state, it's going to be 600 miles. But if it was in a situation like Washington, D.C., in like 15 miles, you cross 3 states, it's perfectly okay. It still comes under the same MSA, so you could still work at home, no problem with it. Now, Emily, how about if my job is in Michigan? And now my house is located in Texas. It's not listed in the LCA. Under what conditions, how many days can I work? And if I want to prolong the work, what is that I need to do?
Yeah, so the general rule is that if you're going to work in a location that's not listed on your LCA, a new LCA, an amended petition has to be filed. But there is an exception called the short-term placement provision that allows you to work for up to 60 days in 1 year at a location that's not on your LCA, as long as you normally have a place, an office space at your normal office location. There are certain provisions that have to be met, but you do have the potential for working from that home location for up to 60 days. If it's going to be extended beyond 60 days, then a new LCA and an amended petition are required.
Nilesh has this question, what is a better way of extending the L1 visa? Is it through USCIS or through Consulate? Very tough question.
I answered that one already.
Huh? Okay, sorry.
Yep.
Oh, you're okay, sorry.
Pampana from YouTube wants to know if premium processing for H1 extensions is still a possibility. I've heard there's no impact. Unfortunately, there is no premium processing for anything right now. There was a little bit of confusion because we had an announcement that eliminated premium processing for the CAP subject cases, so that let everyone else still do premium processing, but then it was suspended for everyone due to the COVID-19 situation. Srinivas from Facebook had an H-1B transfer that was filed at the beginning of April and has not received a receipt notice yet. Any ideas what's going on? How long does it take to receive the receipt? Well, I would say in general, we're not seeing much of a delay in receiving the receipt notices for H-1B petitions. There might be a delay due to people, if this is going to the attorney's office or the employer's location. If people are working from home, maybe they're not going to the office every day to grab the mail and figure out what's in there. But in general, it doesn't take a month to get the receipt notice, but you do have to wait 30 days before your employer or attorney can contact USCIS to say it's missing. Raj from YouTube wants to know if H-4 EADs are eligible for unemployment. The answer is generally yes. The H-4 EAD is an unrestricted EAD, meaning you could be working as the CEO of a company today and go and get a job at McDonald's tomorrow. You could work anywhere for anyone. So that means you are generally eligible for unemployment. And taking unemployment benefits does not count as a public benefit for the public charge rule. That's something that you and your employer pay into every month. So it's more like an insurance, and you're using the insurance that's been paid for.
Ekalavya's H1 EB1A got approved. His priority date is October 2019. When can he expect the priority date to be current? I would, right now it looks to be that the priority date is 2017, lingering around 2018 for the filing dates, which is actually not, USCIS is not allowing the filing date, at least for the month of May. So you may want to have an alternative plan. I'm assuming that you may have been on L1A or L1B, most probably L1A. You may want to consider if in the next year quota, if you're not applied for, to apply for the H1B to stay in this country. Because it may take a long time for your priority to become current, and you cannot extend the L1A beyond the 7 years. So if you move to the H1, you have a better chance of extending beyond the 6 years limit or beyond the 7 year limit. So if I were you, I want you to have an alternative plan of if the priority date does not become current by the time your visa status expires. What is the alternative thing?
Rada from Facebook says her employer says she's eligible for unemployment on STEM OPT and wants to know if that's true. I don't think that's true. The STEM OPT is a restricted EAD card. It is only authorizing you to work for an E-Verify company that has the training plan, completes the 983 form, and is in your degree field of study. So as I mentioned earlier, if you work for your STEM OPT employer and the next day you can't go and get a job at McDonald's because that's not in your field of study, they might not be E-Verify, they're not doing a training plan. So if you have that restricted EAD, you're not eligible for unemployment.
Vijay has this question. Filing citizenship, got the green card through the spouse. Can he file the citizenship if his wife is not filing the citizenship? Yes, you can. You are not linked with your wife that much. So your wife and you can apply citizenship independently. It's not going to affect each other person though. Though you got the green card through your wife's employment, it will not affect if you just file the citizenship and your wife does not file it. It's perfectly all right.
Shalini from YouTube is currently stuck in India due to travel restrictions and wants to know if they can file the H1, H4, and EAD extensions from India. Unfortunately, only the H1B extension can be applied for at this time. For the H4, you apply for that at the consulate once the H1B is approved, and you cannot apply for the EAD until you're actually in the US in H4 status.
Neelis has this question. Can we file a H1B for the non-profit organization right now? Because it should not be coming under the quota. A lot of people are under the assumption that non-profit organizations are exempt from the H1B quota. Neelish, the correct word is not just non-profit organization. It must be a non-profit and higher education institution. It has to be both, not just non-profit organization. But if it falls into the criteria of non-profit and higher education, yes, if you find a job and they're willing to file the H1B, you do not have to wait for the quota to open, which it's going to open in where we can file in March of 2021, and it won't start until October 1st, but you can file immediately without subject to quota. Suri Shuda has this question from Facebook. If the H1B is revoked but I-94 is still valid, how long can you continue staying in USA? You have a 60 days grace period that's allowed to stay in if the I-94 is valid. In this 60 days, you can leave the country, or you can move to H4 if you're eligible for, or you can find another employment to move to file another H1B. And if the travel restrictions are there where you can't fly or the things are banned, you may even want to consider filing a B2 application to stay for a while until things get better to travel outside the country.
Srinivas from Facebook has an approved H4 already and applied for the EAD a month ago from the Vermont Service Center and wants to know how long it will take to get the approval. So the good thing is because you already have the H4 approved, you don't have to worry about the biometrics being an issue or the I-539 processing times. The I-765 processing times aren't that great anyways. It's still probably 4 to 6 months. But you can check that on the USCIS website for the I-765 processing times to get exactly what it is at the Vermont Service Center.
Self-Made has this question. Looks like he sounds like me. He's an H4 EAD. Can he work for 2 employers? Yes, you can work for 2 employers. And this is another news. I mean, H4 EADs can work for any number of employers. Can the H1B people work for 2 employers? This question is coming very much right now because people are working from home and they're bored. They want to work for 2 jobs. Yes, you can. You can have the second H1B work, file a called parallel H-1B. You work for company A full-time, company B, you can even work for 2 full-time jobs. Company B can file a H-1B with a parallel H-1B, and you can be getting 2 paychecks. A lot of people are confused, they cannot work. No, you can work. This country wants people to work more. We want your taxes. You work more, pay more taxes. So yes, you are allowed to work. H-4EAD doesn't have any restriction. H-1Bs, they just need to file 1 more parallel H-1B and work for 2 employers at the same time. Are they under the obligation to inform the other employer? As far as immigration is concerned, no, they are under no obligation to inform the other employer.
One last question for today. I think Amigo from YouTube wants to know, his H-1 extension is in process. When is it actually considered to be filed? Is it when the package reaches USCIS or when they actually generate the receipt number? So it's technically only considered to be filed when it's properly filed. So if the application was mailed and received at USCIS but was not proper, maybe it's missing a page, missing a signature, missing a check, wrong amount of the filing fees. There's so many things that can go wrong in the filing. That is not considered to be filed. It's only filed when it's properly filed, and that you can tell is when the receipt notice is actually issued by USCIS.
Thank you guys. Anything else, Emily?
I think that's it for today.
Thank you very much for coming and joining, and please tune in for every week. We will bring you the practical news of what you need to know. We understand you because we deal with immigration stuff day in and day out. Thank you guys for joining.